So, good morning or good afternoon, dear ladies and gentlemen. It is our sincere pleasure to welcome you to today's webinar on data protection in Southeast Asia. Well, data privacy has been quite the talk of the town for a while now, but it experienced a significant increase in topicality due to the fact that so many physical events, meetings, and even negotiations had to be shifted to virtual platforms due to COVID-19. So today we will take a close look at the status quo in Singapore and Thailand as examples for the region, and in more general at what to expect in 2021 with regard to data privacy in the Asia Pacific in light and beyond the pandemic. We are most delighted and equally honored to have Dr. Clarisse Giraud on board as expert speaker today. Dr. Giraud is the data privacy project lead, at the Asian Business Law Institute in Singapore. The Data Privacy Project aims at promoting the convergence of Asian business laws with a focus on searching for solutions that facilitate trade and uphold data privacy and data protection at the same time. So Dr. Giraud falls back on an exceptional expertise with a most practice-oriented entrepreneurial view. And just recently, she published a paper on transferring personal data in Asia titled Path to Legal Certainty and Regional Convergence that has been awarded the 11th Annual Privacy Papers for Policymakers Award by the Future of Privacy Forum. This is not only remarkable in itself, but it's literally outstanding because so far this award has only been granted to papers written and published by representatives of American universities. And this time as well, 5 out of 6 winners were originating from the US, except for Dr. Giraud. So we are happy and honored for you to share your time and expertise with us today. As to the schedule of this webinar, we will start with Dr. Giraud, who will then be followed by my dear colleagues Paul Weingarten and Martin Krometzka, who will highlight the specific challenges and regulations with regard to data protection in Singapore and Thailand. We will round up our program by a Q&A session at the end of the presentations for you to submit your individual questions. As always, this webinar is being recorded and will be made available online for you and your colleagues to recap anytime you wish. So looking forward to a most enlightening session. It is now my pleasure to leave the stage to Clarisse Giraud.
Thank you so much, Bettina, for the kind words, and thank you also for the invitation, Rödl and partners. It's really a pleasure to have the opportunity to present our work and the lessons learned from our project to this distinguished audience. We're very pleased in particular because it's quite rare to have the opportunity to present to European stakeholders. And I'm extremely happy, in my case, being French myself, when this Asian expertise can be shared with European friends and partners. So my role to start this session is basically to provide you with an overview of data protection in Asia Pacific at large, and then we will focus on ASEAN, Southeast Asia more specifically. So that you can get a flavor of the trends in this region, which is increasingly attracting more and more attention because, of course, a lot of business takes place here, but also because a lot of data protection laws are being passed, and there is a lot to expect in 2021. Already a lot happened in 2020, so it's important for you to be aware of this regional, global and regional movement before we dive more specifically into Southeast Asian developments. So Bettina, next slide, please. Thank you. So to put APAC data protection laws in global context, as I was mentioning, it's important to look at the global context. And you can see from the slide, and in particular the chart on the right-hand side, how data regulations have been booming globally, and particularly in Asia. So by data regulation, we mean data protection laws. There's been a boom, obviously, in the 1980s and 90s. This is when Germany and France adopted their data protection laws. But today, the trend is truly driven by Asia, Africa and South America, we're going into a world where data protection laws will be basically common in every single national framework related to data. And in fact, a country without a data protection law and without a cybersecurity law is considered now as honestly lagging behind in the digital economy. So figures vary. I'm not going to burden you with how many laws there are in place. You get the idea. There are variations between experts on this, but basically more and more data protection laws. Next slide, Bettina, please. So as we go into 2021, of course, it's impossible not to mention COVID-19, even though we're all sick of it, tired of listening to all the, fighting the pandemic, what does it take, and so on and so forth. That said, it's unavoidable because in the area of data protection and data flows, basically the privacy implications of fighting the virus are huge and are in every regulator's mind at the moment. So we all know that COVID-19 has accelerated, well, the crisis, not the virus itself, but the crisis has accelerated the take-up of technology across many sectors. We're working from home, we're listening to this webinar from home. Without data flows, this would not be possible. We streamline, for leisure, we pay online, we order online, we do everything online. And at the same time, for governments and regulators, the other important aspect of the pandemic, of this crisis, is that they need to beef up the public health response and accompany this response with measures which are not too privacy intrusive as much as possible, even though we know that there have been very intrusive measures taken in some countries. But this has driven a lot of privacy expectations from individuals and from businesses as well. Everybody's concerned, and it's also true in Asia, even though you hear it very often, Asians do not care about their privacy, which is not true. It has driven privacy expectations really very high on the agenda, and in a number of situations, actually, some governments in this region have been, sometimes been in their tight shoes to explain, justify what they have been doing, and some things without explaining them well enough. So this is really driving the privacy agenda in this region, and this will go on far in 2021. And another aspect which has to be mentioned is that there's been a surge in cyber attacks during the pandemic. So if you look at official reports from Interpol in particular, but also from industry, and I found the Cisco report 2019 already enlightening. We're waiting for the 2021. Clearly, APAC, ASEAN in particular, are really the center of cyber attacks in this region. There's a lot happening in Thailand, so we will probably hear from Martin later what's happening there. But Singapore and Malaysia are also very attractive targets for hackers. So all of this creates an environment where we need more data protection, not less, and more international cooperation. Next slide, Bettina, please. So this is just a copy paste of a few screenshots that I've taken just to show you how important privacy, data privacy implications of COVID-19 are actually looked at in a lot of forums. Just to let you know, this is not just a fantasy from a former European regulator that wants to believe that privacy is taken seriously globally. It's actually very true. OECD is working very hard on this, WHO, G20, the regulators themselves, both in Asia Pacific, the so-called Asia Pacific Privacy Authorities Forum, but also the so-called GPA, which is the Global Privacy Assembly, the group of data protection authorities worldwide. Everyone is working on this, and it's actually very interesting to see how different worlds actually come together and try and collaborate on these issues, because no one holds the universal truth on how to deal with the privacy implications of fighting the pandemic. A lot happening out there, and Asian jurisdictions are increasingly present in all these forums. This is the message I wanted to carry to you, and in particular from Singapore and Philippines. Philippines play an instrumental role in ASEAN on data protection at the moment. I'll explain to you why later. Next slide, please. Now, I was telling you, I can't stand this phrase, Asians do not care about their privacy, because it seems that it's easy to collect data and do pretty much whatever you want across the region. Asians do not care. First of all, Asia is not a bloc. It's a combination of very different countries with very different sensitivities to these issues. But generally speaking, Asians do care about their privacy. And it's very striking if you were now in Singapore, like me, and you would see all your contact numbers switching to Signal, leaving WhatsApp. I mean, most of them are actually my Asian contacts doing so. I was honestly surprised. There is genuine growing privacy awareness in this region, and there is clearly also an intention from the data protection regulators and governments to be more serious about enforcement, even though the enforcement threat, if you will, is not the same in all countries. And of course, we're focused on ASEAN today, but it's important to see that Chinese tech companies, which are providers of technology solutions, a lot of them in ASEAN, are actually also under pressure from their national government, but from the Chinese people as well, to be more transparent about what they do and to implement more stricter privacy protective measures in their goods and services. Of course, China is a problem of its own, I would say. We're not going to discuss this later, but there's a very serious concern about improving privacy protection in China. This is not a joke at all. Next slide, please. So just to finish on these common trends and this, to finish this overview of regional developments, there are more data regulations in APAC, as I was mentioning earlier. What is very interesting is to see that this trend basically follows the global trend, which is that at first, the first laws in this region from typically Hong Kong, Japan, Australia, New Zealand, if you count them as Asian, which we usually do, have actually followed the basic principles in the OECD privacy guidelines or in the EU Directive 95/46. Also the APAC privacy framework, which is an emulation of the OECD privacy guidelines. Now, the second generation is actually beefing up the protection and following more stringent principles and rules and policies, which are found in EU GDPR, but not only in EU GDPR, but what I call modern data protection laws. So some provisions actually, which might be in GDPR, actually come rather from Canada or Australia. There's basically a combination of provisions, if you will, that is happening now in most Asian data protection laws. And these are extraterritorial reach. It's a very significant evolution in this region, in the sense that without knowing it necessarily, when you operate cross-border in Asia, including in Southeast Asia, it's very possible that multiple laws will apply in accumulation because of this extraterritorial effect. Regulators are becoming stronger with significant variations between countries. Concepts like privacy by design, privacy impact assessments, accountability, of course, are being incorporated in laws with variations. Again, protection for children, the elderly, vulnerable group-specific consent requirements, for instance, all of this is happening. Data breach notification requirements are also on the rise in sectoral, but also in baseline legislation. And this is a bit of a challenge for you as you step into Asia or beef up your activities in this region, because there will be significant variations sometimes between data breach notification requirements, and therefore an organization like Cathay Pacific, which encountered a major data breach a few years back, said that it had taken it something like 6 months to deal with all the requirements across the entire region, whether the sectoral regulation in the transport industry, but also with all the national regulators, privacy regulators that wanted to inquire and know more about the breach, how it all happened, and with lots of variations between them, different timelines, and so on. So that's important to know. More data transfer provisions, more or less aligned on GDPR, sometimes combined with data localization provisions. That's a bit of a challenge as well. It's a big challenge, actually. We can discuss that later. That's the object of the paper, actually, that Bettina was mentioning earlier, which we published in May. and more advanced modern rights like portability or the rights to object to processing, rights with regard to automated decision making, very GDPR flavor here, but again with variations. Which means that if you're compliant with GDPR, which you are, since you are commonly based in Europe, as I understand, well, this does not mean you're automatically compliant with all APAC laws, and there's still a need to tailor make your internal policies and compliance efforts to national jurisdictions in this region. Next, please. Oh, yeah, well, I mean, I won't delve into that too much. It's another overarching comment. Well, the challenges are indeed that even though there are lots of commonalities between the laws, as I was mentioning earlier, sometimes the reference models for the laws in this region come from outside Asia. They come from GDPR and so on and so forth. And sometimes it's a bit difficult for some jurisdictions to actually incorporate more than the wording, but also the philosophies behind the original text like GDPR or Convention 108 or even the Canadian or Australian statutes, because we come from different spaces, we come from different backgrounds. So sometimes some concepts are maladapted to some jurisdictions. Sometimes also in some jurisdictions, GDPR-like concepts are honestly too constraining for some countries that are new in data protection, can be a bit cumbersome sometimes, and therefore the regulators are on a steep learning curve. It can be a bit tricky sometimes to just reach out to the regulator and expand the privacy program in some regions, because simply the regulators might not be aware of the intricacies of doing so. Another challenge, and I won't say more than this, is that the approach to cross-border data flows in Asia is increasingly complicated to comprehend and apprehend in practice. In China and India, for instance, where big data protection laws are coming, there is a mix of data localization policies inspired by digital sovereignty, tech nationalism, national sovereignty, law enforcement access to company data. All these concerns drive the localization provisions, which have been combined with traditional transfer provisions as we find them in Europe. And this can create some confusion sometimes as to the exact purpose of the statute, how it's going to be interpreted, how some key notions will be understood by the regulators, because depending on how you look, if you're a privacy regulator or more of a cybersecurity regulator, well, of course, you will not have the same kind of reading of similar provisions. So that can be tricky, and I anticipate that in 2021, one of the challenges will be to look at China, India, but also countries like Indonesia and Vietnam, how they actually deal with this combination of localization and data transfer provisions in their future data protection law. And to close on this slide, time is of the essence, as we all know. All these developments are taking place on different levels and on different timelines. It's actually very difficult. There's a lot of legal uncertainty in this region because laws come out in very different times. Reform is announced and take much more time than you would think. A law is passed like in Thailand, but then implementation is delayed. It's very hard. It's a lot of stop and go, a lot of uncertainty. It's really an uphill battle for the lawmakers, well, the government first to draft a bill, then for Parliament to discuss it, and then for the regulators to enforce it. It's a long process, and legal uncertainty is going to be, I think, significant in this region for at least 2 to 3 years at best. Next, please. So let's dive into concrete cases. So I've done, in the coming slides, I've done an overview of the game changers on the horizon. And I don't think I will go too much into detail because it can become a bit cumbersome. And I have agreed, of course, that these slides can be shared with you after the webinars if you want to, and all the links are clickable. So China recently released a draft personal information protection law called PIPL, which was introduced for first reading in the by the Standing Committee of the NCP in October. it's very hard to know how much time it will take for China to actually pass this law. Officially, the intention is to go very fast, but that's always the intention. We've heard that in many other countries. Realistically, 2022 is, what practitioners say in China, that basically 2022 should be the expected year when people will come into force. And then even when that is done, there will be a lot of time needed to actually issue all the implementation regulations, and then CAC will have to get in motion to draft policies and so on and so forth. So it will take a while for this PIPL to be passed and implemented. That said, it's important to put this draft law in a wider context, because China has been fairly aggressive in the development of its general data protection framework over the past years. So there still are today a lot of overlapping, even though roughly consistent series of texts and guidelines, frameworks of all kinds dealing with data privacy, mainly in the cybersecurity law, but also e-commerce law, and in the PI standard that was just revised, which is not compulsory, but has been treated as such in effect because it's used by the Cyberspace Administration of China for its enforcement action. All these texts have been used more or less to craft a tentative framework, which is now crystallizing, if you will, in the future PIPL, but also in a data security law, which is also in draft, and currently I think the public consultation has actually closed, which is actually very important to understand where China is going. So we have a mix of significant privacy protections, and here, I mean, I know the people who are drafting these texts. I can tell you they're very serious about implementing strong privacy protections. They're really looking at what's happening elsewhere. They follow the developments in Europe and the United States extremely closely. Each time the European Data Protection Board issues an opinion on whatever topic, it gets translated into Mandarin and thrown on WeChat within 2 days. There is really an intention for China to be an active player in this world, and as soon as this PIPL is passed, I think we can expect the Chinese regulator to want to try and become more influential in the global data protection community, which has its own challenges, of course, but still the intention is there. So, in a very important development to watch here. Next slide, please. Another game changer takes place in India. India has released a data protection bill, which has been in the making for nearly. It's a never-ending story. China's draft data protection law has been in the making for the last 10 years. There was a first draft that was withdrawn, but then a historic judgment was handed down by the Supreme Court of India 3 years back in 2017, which kickstarted the process again. India wants to be a key player in this region on everything data protection and privacy. The intention of the Modi government is to chart a fourth way, which is a very Indian way of putting things in data protection, a word which is not European, not American, not Chinese, an Indian way, and it wants to emulate more countries, in this direction. And what is this? This direction is a mix of human rights concern. India is the world's biggest democracy. Privacy has been qualified by the Supreme Court as a fundamental human rights protected in the Indian constitution. So that brings India very close to a European philosophy in data protection, if you will. But there's also an intention to make India a leader in tech and going up the global value chain to become less of an outsourcing hub and more of an aggressive tech player. And for this, there's also a flavor of digital sovereignty in the act, in the draft, as I was mentioning earlier. Localization provisions which aim at protecting Indian data from accessed by foreign law enforcement authorities, but also at boosting a local digital economy. These provisions, particularly on localization and transfers, have been heavily discussed, well, when the government was crafting its draft, but also now in Parliament. The Joint Parliamentary Committee that has been reviewing the draft bill has been working on this text for a very long time. Something like 69 amendments have been brought to the original text, so we don't really know what it will look like, but it's going to be introduced formally in Parliament in 2 weeks' time. So it's a very heavily GDPR-inspired law, but with lots of specificities, and it has the capacity to emulate other countries in the region. And in ASEAN, I could imagine countries like Laos or Cambodia following India as much as ASEAN trends. So definitely something worth watching here. Next slide, please. Now, we're diving into ASEAN. ASEAN is extremely interesting. As you know, those of us based in Singapore and Thailand know, never a dull moment in ASEAN. There's always something happening. So ASEAN is trying to move together as a group on data protection and data flows. And of course, there are national developments which distinguish some countries from others, but there's still an intention for ASEAN to move together as an association of Southeast Asian nations on this. And Singapore and Philippines are driving this trend very heavily. Philippines and Singapore are very like-minded partners in that area, pro data flows. So they've been instrumental in the adoption of the ASEAN digital data governance framework, which has a number of pillars, if you will. One of them is the ASEAN cross-border data flow mechanism, under which a ASEAN model contractual clauses for data transfers inspired by the European standard contractual clauses have been developed. I've been involved in this work indirectly. The clauses are going to be published normally this week. They're inspired by EU clauses, but of course made lighter to fit an ASEAN setting. And there's also an intention to create an ASEAN data certification mechanism for data flows on the model of EU GDPR, but mainly to articulate this certification mechanism with another one called the APEC CBPRs. I won't go into details, but clearly the intention is for ASEAN to try and reconcile the influence of all the key players in this region, meaning from APAC, including the United States, but also China, since China will have a certification, privacy certification scheme probably later on, and also EU. So ASEAN is trying to reconcile all of that. The background is a bit more complex than that, of course, because it's not only a trade issue. Privacy and data flows also are actually deeply rooted in government issues and also in the public health response to COVID-19. There's also been a huge increase in data breaches in ASEAN. So at national level, of course, developments will deviate sometimes from an ASEAN, purely ASEAN framework. Next, please, Bettina. I won't go into Thailand and Singapore because this is Paul and Martin's turf. But just to mention here that Thailand and Singapore have just been through important review and reform. They're very interesting countries to watch. Of course, everything happening in Singapore is worth watching. But Thailand is bound to become an important player in this region as well. Next slide, please. I will not read all of this to you because that would be terribly boring. Just know that Philippines, that has a Data Privacy Act, that's 8 years old, is working on revamping its Privacy Act and to align it, therefore, closer with GDPR, extraterritorial effect, stronger enforcement powers to the National Privacy Commissioner, extended data protection rights for data subject, data breach notification requirements extended, appointment mandatory in principle of a data protection officer, and so on and so forth. This is in the making. It won't revolutionize the Philippines framework entirely, but it will be an important evolution for Philippines, especially when you know that the Philippines Privacy Commissioner is actually the chair of the so-called ASEAN Data Privacy Forum, Data Protection, Forum, and is driving a group of regulators and governments working on data protection and data flows in ASEAN. So all that happens in Philippines is really worth watching. Malaysia, rather old act, 10 years old, PDPA, also being reviewed. This is more than just a review. If the consultation paper that's been put out by the Data Protection Commissioner of Malaysia is followed by government and then parliament, but of course we don't know, these modifications would be very significant, and in particular because it would expand the scope of the act to the entire public sector, which is exempted today. So that's a huge move for Malaysia. And that might be a reason why the process will take much more time than one would hope, because of course the public sector, when it's exempted, isn't particularly like being covered all of a sudden by such a far-reaching statute. That said, same direction, DPOs, data protection officers, data breach notification requirements, data portability, extraterritorial effect, it's all in there. It will be a very significant modification, and ASEAN work is actually instrumental in getting Malaysia moving on this. Also because Malaysia has the ambition to be a health data hub in ASEAN and regionally in APAC, and is working on this very aggressively. So that's another reason why the PDPA is being reviewed. Next, please, Bettina. Okay, Indonesia and Vietnam. They're a bit of the difficult ones on the team, on the ASEAN team, I would say. Difficult, why? Because here in both Indonesia and Vietnam, there are strict data localization provisions that are either considered or already in place, which reveal that the government is looking at data protection and data flow regulation as a way of regulating digital sovereignty and positioning their countries. Everybody is zooming in on Indonesia, the world's fourth, most populous country in the world, a very promising economy, and Vietnam, which is still a tiger in this region. They want to reap the benefits of the digital economy to the maximum, and for that, having a fairly demanding, approach towards data flows, mandating localization of data onshore in a number of circumstances is considered as essential. The data protection law in Vietnam, I will start with Vietnam, is actually is in the making. It's a long process, and the reason why it's a long process, it's interesting, is that Vietnam is looking at its data protection law, of course, to its future law, as of course a way of boosting the digital economy. Very young population that has entirely leapfrogged the desktop phase. The population is on their phone all the time. If you've been in Vietnam, I mean, you see it's just incredible, this young population that's so heavily digital now, even in remote areas. So there's that intention, but there's also an intention to protect vulnerable groups and to ensure that there's a true development policy behind the rollout of a data protection policy nationally, in the sense that this will go hand in hand with the development of a complete ID system, the rollout of social health programs. It's a very comprehensive law. We don't know if it's going to bind both the public and the private sector, but it's a very ambitious program. Now, one of the challenges in Vietnam is that the drafter is the Ministry of Public Security. Well, basically the strong man in Vietnam's institutional framework, which is an indication of how important the law is, but it's also an indication that ministries that are traditionally discussing with industry are not as influential in this lawmaking process as public security officials. So we will see where it goes, but from the relations which I have with MPS, honestly, they're friendly and welcoming. They want to do things well and be aligned on, of course they want to, and they're super sharp, and they want to align on regional and global standards, are also looking very closely at EU GDPR, but with the concern of tailor-making it right to the Vietnamese economy. So the cybersecurity law, I've listed all these laws, but they're not particularly interesting, but they show where Vietnam is going. They want to condense all these provisions on data protection in one single statute that will walk hand in hand with the cybersecurity law, with its heavy data localization requirements in it. Indonesia is different. Indonesia has also adopted a similar approach, but it's still different. We have hopes that the law will be adopted very soon, but in Indonesia you must always expect the unexpected. So I wouldn't dare say anything, but it's likely the law will be adopted soon. Next slide, please, and I will be faster now. Just for your reference, important changes just made in Japan and Korea, and in Hong Kong, the privacy ordinance is also under review. There are still important developments to watch because they are very advanced countries in data protection, very sophisticated legislations, and what happens in these jurisdictions is likely to happen elsewhere. And they're not necessarily following GDPR entirely. They take a more Asian-specific angle to lawmaking. So it's important to watch this. Next slide, please. And New Zealand and Australia also moving. New Zealand just adopted a new Privacy Act, complete revamp of its former act, and Australia is working on a very deep reform of its current Privacy Act. Very important to watch what's happening here, especially in Australia. Next, please. The result of all of this, uncertainty, fragmentation. I'm sorry that I mentioned, I posted a map from a competitor of Rödl and Partners, but that's a slide which I've been using in previous presentation. You might disagree sometimes with the qualification here, red countries, orange, green. This is just to show you the perception by businesses and law practitioners of how to approach data protection and data flows in this region. In other words, even though there are commonalities, the situation is complicated and you need to tailor-make your approach to each and several country. Next, please. I won't go into this either, just to show you that uncertainty and incompatibility of legal regimes is a key concern also for regulators. It's an impediment to regulatory cooperation. It makes the implementation of consistent policies and data flows more cumbersome. That's an interesting chart, I find. Next, please. So where there is hope is that there are channels to advocate for convergence, either at national or regional or global level. This is what we have tried to do at ABLI. This is not my advertising moment. This is just to show you that even though the situation is complicated, there are ways in which industry, law practitioners, public and private stakeholders can actually get into the discussion and try and influence all these developments in this region. It's time consuming. It's not easy. You need to talk to the right people. It might take a bit of time to identify them. I'm happy to help in that respect. I think it's important for European businesses in particular, which are just absent, honestly, from these regional discussions, to get in there and talk, and in particular, because some governments are really desperate to get hold of SMEs that can be extremely candid on the challenges which they face in the implementation of such fragmented laws across this region, and want to help SMEs, more. SMEs are lacking in the picture, and European companies, which are GDPR compliant and have made tons of efforts and spent a lot of money on being GDPR compliant, are not reaping the benefit of all these efforts in Asia, and yet they could. There is a lot happening in this region, public and private consults, reports being drafted, conferences, all sorts of things that you could consider doing to explain your own concerns and make sure that you are heard as European companies. Next, please. Again, well, okay, there's my name there, so it looks like I'm a bit boasting here. It's not very nice, but this is just to show you the list of a short list of all the organizations that are working in this area, trying to facilitate data flows and consistency. There is always a business association somewhere. There are always industry representatives in all these forums, and I would love to see more European companies involved in these discussions. Honestly, this is lacking, and I find it's a pity. You know, as still a European, I believe that there is something that European companies can bring to this discussion. It would be extremely interesting. Next, please. I think I'm done here. Yes, thank you very much. This was my last slide, and I'm happy to well, take questions afterwards. This is a lot of information, but well, I'm still very happy to have shared it with you. Now, Paul, your turn.
Thank you, Clarisse. After this very interesting, I would say captivating overview on what's happening in the region, on the recent developments as well, I think this session will now get a bit more technical, maybe also a bit more into detail, because we will look into the amendments to an existing data protection law in Singapore. So I will try, of course, to focus a bit on the more important points for you as a business and make it a bit less technical with providing some examples. So we will look into the amendments and at the aims of the amendments in particular. What is the intention here? Why is the data protection law already amended? And in my conclusion, I will try to give you a few to-dos, what you as an organization can do to ensure compliance with these new amendments. So let's have a look at the PDPA and its amendments. The Personal Data Protection Act in Singapore was actually one of the first laws of that kind in the region. So Singapore was on the forefront when it enacted the Personal Data Protection Act in 2012. Of course, at that time, Singapore took the EU legislation, at that time, the EU Data Protection Directive, a bit as a basis. So you would find similar concepts already at that time. Singapore is now again probably one of the first or the first country to completely revise its Personal Data Protection Act. And again, the developments in the European Union, the GDPR, the General Data Protection Regulation, which is a direct applicable law in the member states of the EU. Most of you will be familiar with it, or at least you heard of it, because it made big waves in the media as well. Again, this law, plus of course regional developments, what Clarisse has very well pointed out and mentioned, there's a lot going on also here in the region, and increasing concern, or I should better say awareness of data protection, together with cybersecurity aspects and so on, lead to a complete revision of the Act, and we see a few amendments which we will discuss now. Maybe again on the just to give an introduction to the topic on the PDPA. The PDPA, the Personal Data Protection Act in Singapore, governs the collection, the use and the disclosure of personal data by organizations in Singapore. That is the scope, right? The scope is slightly different, for example, from the GDPR scope. In Singapore, public agencies are excluded from the scope of the PDPA, and also business contact information is not considered personal data within the scope of the PDPA. So this is one big difference. But let's recap first. Maybe I said the PDPA governs the collection, the use and the disclosure of personal data by organizations. So it addresses organizations. Organizations are companies, any type of organization foundation, form of company, sole proprietorship, whatever it is, right? Basically, there are a few obligations you're probably familiar with. I just want to very briefly recap it so it's easier then to come to the amendments. Before or at the point when you collect personal data, you need to inform the data subject, as we call it, the individual, of the data collection. And you also need to inform them of the purpose that you collect it for. In most cases, you would need to seek the consent of this employee, of this individual, for the data to be collected by you. And you need to stick to the purpose that you collected it for when you use it. You cannot change the purpose. You cannot use it for other things. You can only use it for the purpose it was collected for. And you can only use it as long as you need it for the purpose that you collected it for. So you also have a data retention obligation to sort of erase or get rid of personal data when you don't need it anymore. In addition, you have an obligation to protect personal data. It is something that is entrusted to you as an organization. You have to take reasonable measures to protect personal data. And you have an accuracy obligation, so you need to make sure the data is accurate, and you have to allow individuals to access their data, to probably request to update it, make it accurate, and so on. Again, in the European context, the individuals have even a right to request for their personal data to be deleted, which is not the case in Singapore under the PDPA. I don't intend to do a comparison between GDPR and PDPA, so the Singapore and the EU legislation. There is quite some differences in detail, but in the big picture, the principles are the same, right? Both know a data controller and a data processor. Both would have actually quite strong enforcement authorities and wide-ranging powers for the Data Protection Commission in Singapore and the different EU agencies to enforce the data protection. Both would have or would foresee a data protection officer that organizations need to appoint under certain conditions. Again, the details here are different. But of course, one thing that you may also know from the media is that the fines that the European Union or that the GDPR can impose, or that can be imposed according to the GDPR, are strikingly high and probably much higher than what we see here in Singapore. But even in Singapore, we should note that the Personal Data Protection Commission has really increased its activity over the last years, its investigation activity and also its fines. So in 2017, for example, the total amount of fines that were issued in Singapore were about 95,000 Singapore dollars. In 2019, the Data Protection Commission issued fines of altogether 1.5 million Singapore dollars. Of course, we had a very prominent case, already mentioned the SingHealth case, but still it shows that there is an increasing enforcing activity as well. So another good reason for you to be in compliance, not only with the European regulations, but also with the local regulations here in Singapore. This brings me now to the next slide. Actually, we want to look at the aims of these new amendments. One move is we clearly, or the PDPA clearly moves from compliance to accountability. What does this mean? Accountability means that it's not enough to be merely compliant, but in addition, the organization has to demonstrate that they are compliant. So it will require you to constantly monitor your compliance and to be able to document it and demonstrate it also to the outside world that you are in compliance. There are two new accountability tools introduced by the amendments. The Personal Data Protection Commission has launched a Data Protection Trust Mark certificate. So as an organization, you can apply, and if you pass the investigation test, the Data Protection Commission will really look into your organization. This includes that they will probably physically come to your premises and investigate. And if you fulfill the criteria, you get a trust mark. So a lot of bigger Singapore operations would already have it, like DBS, Shangri-La, AIG, the insurance company. They are such data protection trust mark certificate organizations. In addition, you have a data protection impact assessment. That's also something we already know from the European Union. It's required on a periodical basis, and you basically do a self-assessment. How robust is your organization when it comes to data protection? Another new feature, another new obligation actually that also is linked to the accountability is a breach notification scheme. Again, it is not surprising that Singapore introduces this. We see it in many countries. Meanwhile, the European Union again was one of the first to introduce with a very, very short time frame. And now Singapore as an IT hub, we've just heard that there is a lot of cyber attacks, and at the same time Singapore puts quite an emphasis on the management of cyber risk. So it is not surprising that Singapore also introduces this mandatory breach notification regime. It basically means that an organization, or you as an organization, have to notify the Personal Data Commission of any unauthorized access or other similar risk to personal data that is occurred, or that you have evidence of an occurrence. That could be the loss of a storage device, right? It could be a hacker attack. It could be human error that leads to personal data that is misused, misdirected, and so on. There are some criteria you have to report. So it must be likely that the result, that this breach is a result in significant harm or significant scale, so 500 or more individuals. If there is significant harm, you may also need to notify the individuals concerned. So basically the notification has to be done without delay. I mean, you have to immediately start an analysis, an investigation in your organization to actually see whether the breach could have lead to this significant harm. And if so, if the criteria met, you have to notify PDPC no later than 3 days after the termination of the criteria met. What does it mean, significant harm to individuals affected? Well, it could be physical, emotional, financial harm, even harm to reputation, right? So the PDPC has issued some guidelines and said, well, this data is typically able to cause significant harm. And the guidelines mention financial information, account information, health data, key to be used for electronic signatures, any passwords, access codes, and so on. Of course, in combination with the name, right? So since there's a very short period of time for you to decide, do I have a case that I need to notify or not? And if so, I need to make notification, which would include a number of information you have to provide to the Data Protection Commission. So you should really have a data breach or data incident response scheme plan in place, right? In your organization, you should know what you would do if you have actually some hint of some data breach, data leakage in your organization. And probably as a global organization, you would have something at your global level, but please consider localizing this so that it really meets the requirements, the new requirements under the amendments of the PDPA. Okay, then we look at the next aim of the amendments. Next slide, please. Accountability, of course, is first addressed to organizations, right? The entire PDPA, the entire Personal Data Protection Act, addresses organizations. But now the intention is to also address it to individuals handling the personal data. So we have new offenses introduced for individuals, for employees, for example, mishandling personal data. I mentioned here the SingHealth data leakage. It was in the media, probably most of you know it. It was the big data breach case in Singapore in 2019. About 1.5 million personal data of Singaporeans, including its prime minister, got stolen, like the records got accessed and the data was copied. And part of it was even health data, right? So this was a very big thing, of course, and it led to two new aspects. One is that organizations acting for public agencies are no longer excluded from PDPA. I've already mentioned it. I think the PDPA excludes public agencies, as opposed to the European legislation that does not exclude public agencies from its scope. The PDPA in its current version also included organizations that act for private agencies, that process data for private agencies. This exemption will now be deleted, so only private agencies are excluded, but not organizations who process data for for public agencies. And the second aspect, I just mentioned it, the PDPA addresses organizations, but here it introduces new offenses, criminal offenses for employees. So if you're an employee and you handle personal data in the scope of your employment, according to your employer's policies or with the authorization of your employer, then you would not be subject to these offenses, right? It targets employees who misuse their position to actually get a personal gain by stealing, copying, mishandling personal data which is entrusted to them within the organization. That is the aim. And the penalty is $5,000 or up to 2 years of imprisonment or both. So this closes basically the gap of the PDPA that addresses organizations' responsibilities and now also includes the person's personal responsibility handling personal data. Another aim is the consumer autonomy that shall be boosted. I think we can go to the next slide. This has two aspects. One of it is probably the most important. It's the new data portability obligation. So the right to personal data belongs to the consumer, and the individual who has an ongoing relationship with the organization shall be able to have a right to claim data portability to another organization. So it gives greater autonomy to the individual, but it will also boost the development and enhancement of new goods and services. It will level the playing field in areas where a long relationship that includes a lot of personal data would actually maybe refrain or make it very complicated for a consumer to change provider, or for a new provider to enter such a already established market. So imagine, for example, you went to see a medical specialist, you want to go to another medical specialist for a second opinion, and in the future, maybe you can do this without a whole bunch of papers and copies of your exams and so on. The data will be electronically ported, right? Or you change your streaming provider and you don't want to lose your playlist. Or you apply for a new credit card without filling in a whole stack of information of your past records, but you can just ask your existing credit card to pass the data to your new credit card company. So this could lead, of course, to increasing cost in business, but it could also provide a lot of new opportunity for businesses, right? And on the right side of the slide, we see the expanded protection from unsolicited messages. Basically, what is the current situation? You may have heard of the Do Not Call registry. If you register in this register, then you shall not receive any calls or SMS messages for marketing services and so on, right? For emails, we have the Spam Control Act that covers mass emails, spam. And the amendments to the PDPA now expand this protection. It's actually, the bill will also amend the Spam Control Act by including instant messaging accounts like WhatsApp and so on. So this is an additional protection for the consumer, and again, covers the intention or the aim to boost the consumer autonomy. I come to the next aim of the PDPA amendments. Well, I should focus here probably on the most important part, which is the increased potential penalty. It used to be capped at 1 million Singapore dollar, and after the amendments come into force, the penalty for a data breach can be up to 10% of the organization's annual turnover in Singapore. So this could be a significant increase. Please the next slide. Another aim that we should look at is to boost innovation, or to actually make it easier for companies to use personal data to create new products, create new services, improve businesses, improve products. So again, we should be reminded that normally an organization has to seek the individual's consent to collect the data. But here we basically find other applicable purposes for which we can collect the personal data without an explicit consent. So one of the exemptions that are introduced is the legitimate interest exemption, or the business improvement exemption. Legitimate interest, well, it's of course very wide, so you would have to do your own assessment whether your company has a legitimate interest to collect personal data, for example, to detect and prevent fraud, right? So hotels could keep a blacklist of guests who have a tendency of like abusing the services by not paying, and they could share this information and keep this list with personal data involved. They could collect it without the consent of the guests. Or to protect your organization commercial interests, for example, a data protection software that you run to detect your employees' mobile devices in case of loss. So for example, it's a software on your mobile, you lose your mobile, and on a remote basis, all data can be erased or the mobile phone can be detected. So all these are legitimate interests or examples for legitimate interests. The second aspect is to improve your improve your products, improve your services. For example, you want to understand your customers' behavior to then create new products. So a credit card company could, for example, analyze the payment history, the spending habits of its customers to use that data to develop new incentive schemes for the credit card customers. In general, anything that concerns the improvement and efficiency of operations could come under this exemptions of business improvement. Another way to actually ease the companies collecting personal data is by deemed consent, which brings us to the next slide. So it is also to actually enable the use of data by deemed consent. For example, we have deemed consent by contract. Imagine you order furniture, or you buy furniture in a furniture store and you opt for home delivery. It is clearly communicated to you that it will not be the furniture store that delivers the furniture, but that they would use a third-party logistics provider to deliver the furniture. So by providing, of course, your name, your address, your telephone number, you give a deemed consent that the furniture store will provide this information to the delivery logistics providing company to deliver your furniture. Or if you do banking, credit card, you know, one bank needs to notify the other bank, your data has to be probably in multiple hands to make a payment effective in the end. Another example could be a healthcare company that runs one of these apps that collects your movement, you know, where you can monitor how many steps have I done, how many calories per day did I consume, and so on. And this health app company wants to develop a new weight loss program, individualized personal weight loss program. They could use this data probably, they could assess it, and they could use this data because they find that there is no harm to the individual. And they could communicate this to the individual, for example, through the app, through email. And by deemed consent, they could propose then this weight loss program, right? So in detail, of course, there can be a lot of nuances to it. For example, there's one other good case where an association organized an exhibition for its members, and the organization wants to introduce sensors for facial recognition at the exhibition to then analyze the behavior of the members, you know, how long, what time do they spend it with booths and so on. They just put a sign at the entrance that, yeah, the behavior will be monitored in such way. This is not considered deemed consent because you have no applicable opt-out period, right? You're already there and then you're confronted with this, so that's too late. That would not be an exemption under the deemed consent. So I cannot go much into detail here, but it is more detailed, of course. But the takeaway is it can provide you more options to use personal data to actually further innovation and improvement and efficiency of your goods and services. Next slide, please. So this brings us to the conclusion. What would you need to do? Well, you need to review your personal data policies and processes to update them. This is actually something you should do on a regular basis anyways, from time to time. Again, accountability, right? It's not only compliance, it's accountability that you are required to provide. In the light of the new obligation or notification obligations, you should clearly have SOPs for data breach incidents and how you manage such incidents, how you document what you do. This is something that is absolutely necessary for anyone handling personal data. I think the Data Protection Commission will provide more guidelines also on this, but this is a must. You should review your consent collection policies because you may fall under some deemed consent or some other exemptions which I've just mentioned to collect data to improve your efficiency or innovation. You should assess whether you are concerned by the new right of data portability. If so, you would probably need to implement data portability procedures. And of course, you should train your staff. Not only train your staff regularly to update them on any developments, on any additional processes that you have with regards to personal data, but you should also update them on the new amendments and in particular now on the new criminal offenses that are introduced that could theoretically also concern them. And of course, you should review your data processing agreements to have them up to date, include any new developments like data portability, for example. This is also something you should do from time to time. So a lot to come. It will come quite soon, probably. The new amendments will come into force in this year. And I think Singapore is again one step ahead in the region. And since we have had a very good overview by Clarice, we see in what direction it is going. And I may now hand over to my colleague Martin to have a look on what's going on in Thailand and what are the new developments there.
Yeah, thank you very much, Paul. Thank you very much, Clarice, as well. Very, very interesting. Thailand is a little bit at a different stage. While Singapore is discussing amendments, we are hopefully seeing the full enactment of our Personal Data Protection Act in this year. But let's see. So in today's presentation, I would like to cover the following agenda. I will give a quick overview, where are we coming from and where are we going to and where are we right now. Then I will discuss the implications of the new Personal Data Protection Act on businesses in Thailand, obviously as well on data subjects, but for this presentation, obviously business is a little bit more important. And lastly, I will give a little bit of an outlook, though Clarice has already done this basically for me. But yeah, so this is what we are covering today for Thailand. Next slide, please. Yeah, so in 2019, Thailand enacted the new Personal Data Protection Act, the PDPA. However, the law includes a provision that postponed the full enforcement of the act until 28 May 2020. The reason for this was that the government wanted to provide a little bit of a grace period for businesses to adapt to the new law. This makes sense because the PDPA is basically the first, it's not basically, it is the first dedicated privacy law for Thailand. Prior to that, we only had the safeguards under the regular law. And actually, the whole process of drafting the PDPA started in 2015, so it took a while. And then 2019, finally, it got enacted. Then 2020 happened, pandemic and all, and the government decided to issue a decree to postpone the full enforcement of the PDPA for 1 more year until 31st May 2021. The secretary at the time put it nicely and says, hastly enforcement does not help anybody. Probably right. 2 reasons for this from my point of view. Reason number 1 is government did not want to burden companies with additional red tape in an already very stressful situation, economy not in a meltdown, yeah, basically in a meltdown, but at the very least in a very bad spot. Number 2, I think it's also that the government was not yet ready, because the PDPA requires quite a bit of sub-legislation and guidance as to how do we understand these terms, what are the exact procedures and so forth, and I'm not sure that they were in place. So postponed, and but also 2020 saw a huge rise in cyber criminality in Thailand, which has always been a little bit of an issue, but 2020 was really bad. It actually got so bad that they recently, 3 months ago, 3-4 months ago, they set up a new police division, basically, to only address cybersecurity threats. So basically now we have 2 police divisions for that. We have a technology crime suppression division and a cybersecurity crime suppression division. So you can see that this issue is gaining more and more traction. So now, that was 2020. Now we have 2021. We haven't heard any announcement yet, so we are assuming that we are on schedule, that the PDPA will be enacted. However, the issues that led to the delay, they're still there. We still have the impacts of the pandemic in Thailand, and I'm not sure that they already have all the regulations and guidance drafted. So we'll see how this plays out. I did a quick poll yesterday in our office with our colleagues, and the answers ranged between maybe to probably. So probably a little bit more than 50% that it will be enacted. Okay, next slide, please. Yeah, I would like to start a little bit with the foundation of privacy in Thailand, just to give you a rough understanding, because interestingly enough, privacy is protected under the Thai constitution. We actually have a dedicated provision in the constitution that says that a person shall have the right to privacy. And more notably, there is a second paragraph, and this says that exploitation of personal information in a manner whatsoever shall be not permitted unless there is a law that allows for it. So it is actually quite interesting to see that the privacy issue is ranked fairly high under the Thai legal system. And if you compare this to other jurisdictions, for example, Germany, you will not find a dedicated privacy provision in our constitution. Obviously, it is included if you combine Article 1 and 2, but there is no dedicated provision. So that's at least interesting. And you can also see how it relates to the reputation and the concept of face that we have here in Thailand. Actually, the constitution says that privacy is protected, and so is the reputation, so it is connected. So I would very much agree with Clarisse on the point that saying privacy is not an issue in Asia, or at least for Thailand, doesn't really make sense. There might be a lack of awareness, but it's still a relevant issue. Okay, and on the next level, now we have the Personal Data Protection Act. The main purpose is obviously to protect against unlawful collection, use, disclosure, other processing of personal data. So I think this should be the second level. And on one level below, we have the relevant sub-legislation and guidance. This has to be issued by the Personal Data Protection Committee. Unfortunately, this is a little bit of the calamity we're finding ourselves in. There hasn't been any sub-legislation issued yet, very little guidance. Maybe they have it ready, maybe not, I don't know. But this will be very important to fully enforce the PDPA eventually. Also on the last level of this little pyramid, I would say we have other laws that are relevant to the protection of privacy. I don't want to go into details given the time constraints here a little bit. Next slide, please. Let's talk a little bit about applicability. Good news here is, if you know the GDPR, you probably are familiar with it, the PDPA will not will become familiar rather quickly. Clarissa is right, it's not the same, but it is similar. So personal data under the PDPA relates to information allowing identification of an alive natural person, directly or indirectly. So all the good stuff, email, phone numbers, addresses, and so forth, whatever you can think about. And we also have the differentiation between personal data and then one step further, sensitive data such as ethnicity, religious beliefs, sexual orientation, which requires special protection, obviously. To whom is it relevant? Obviously natural persons as data subjects, and for now more relevant to you, probably companies as data controllers and data processors. Same terminology as we find it in the GDPR, and same definition, data controller, how and why of collection and processing of data. Data processor, on the other hand, processing data on behalf of the data controller, can be external, can be internal in your organization. And also similar is the extraterritorial effect of the PDPA. The PDPA is also relevant to organizations abroad. When personal data of data subjects in Thailand is processed for activities relating to the offering of goods and services in Thailand, and if behavior of data subjects in Thailand is monitored. As far as I remember, this is more or less the same wording as we find it in the GDPR. So very similar. Next slide, please. Yeah. So the consent requirement in the PDPA is also very similar to the GDPR. So basically, if you want to collect, use, or disclose personal data, you are required to obtain consent from the data subject, and you have to get the lawful consent. Otherwise, it's not valid, which requires information of the data subject. The information has to be made in plain language. You're not going to get away with juristic gibberish. That's good. And the consent has to be given in a written or in an electronic form. And obviously you have to stipulate a purpose for why are you collecting data and what are you going to do with this. And obviously under the principles of minimal data collection, only collection usage of data in accordance to this purpose is permissible. And obviously you have to provide certain details. Do you have a data protection officer? How can I contact this? Retention periods, all that stuff. And same as in the GDPR, consent can be withdrawn or restricted at any time. So restricted meaning I allow you to do this with the personal data, but not that. Obviously possible. So then there are cases where you don't need consent, exemption cases. Also similar to GDPR, for instance, if I perform a contract, including making an offer, by the way, compliance with the law, also relevant. So if you're reporting to tax authorities, social security, also something like this, that's all allowed. And then obviously other items, for instance, prevention of personal harm comes to mind, or necessary to carry out tasks in the public interest. All this can be permissible. So for companies to take away, you will have to find a way to obtain consent forms that's going to be relevant. Next slide, please. Another issue that we're seeing here relatively often is transferring personal data cross-border, because in our experience, often servers are either located in Singapore or maybe in Germany or at least abroad, and transferring personal data obviously now has to comply with the PDPA, which means that the receiving country has to provide an adequate protection standard, and the transfer has to be in accordance with the relevant sub-legislations. Two problems here. Number one, we don't really know which country has adequate protection standards because it has not been announced yet. We are assuming that the EU countries will be considered providing adequate protection standard, and probably Singapore as well. I think it's a safe bet to say that they will be included. But we also don't know, so problem number two, we also don't know what a transfer in accordance with the relevant sub-legislation is. So this is a wait and see situation. Relevant here would be if you adopt a personal data protection policy, and you get the policy certified by the Commission, by the Office of the Commission. In this case, transferring data to group companies will be deemed to be in compliance with the law. So this will be probably relevant. So takeaway here would be you probably want to have a data protection policy, and if feasible, you probably want to have it certified. Next slide, please. Yeah, and the data protection officer, probably know this from other jurisdictions as well. So you might be required to have a data protection officer in Thailand. What are the duties? So in general, the data protection officer advises the controller or data processor on sorry, can we go back? Thanks. On data protection issues. They have to review the protection performance of controller and processor and advise the management of how to do it better. And obviously, they have to coordinate with officials in case of violations, maybe even with data subjects directly. Now, who has to appoint a DPO? Well, if you're a public authority, probably not, then you will have to appoint one. If you're processing large numbers, large quantities of personal data, you have to appoint one. Here again, the problem, we don't know yet what that means. I think it's a safe bet to take orientation in other countries who have similar provisions. And so lastly, if the data collection, use, or disclosure is your core activity, then you're also going to be required to have a data protection officer. So it's very necessary for companies to review whether or not they will have to have a data protection officer, and if so, then they need to register the officer. Next slide, please. Which brings me to a few other obligations. Nota bene, it's just a few obligations. There are a lot more. I think these are quite important. So you have to have appropriate security measures to prevent unauthorized and unlawful loss, access, use, alteration, correction, and disclosure of personal data. Again, same problem here. What does this really mean? How do I have to, what protection standards do I have applying to my servers and so forth? So this we have to wait and see. We are assuming that if you are compliant with the requirements in the GDPR and storing data in Europe, it would probably be sufficient, but we don't know it yet, so we'll have to wait and see. Then you have to set up a system to review whether or not you need to delete or destruct, erase personal data. So this is the case if keeping the data is no longer relevant for your collection purpose, going back to the purpose of the collection, obviously when the retention period expires, and if the data subjects request deletion, so I guess that is a little bit different from Singapore, they can request erasure. And then lastly, I would like to point out notification requirements. So number one, if you have a breach, obviously you need to notify the commission, the data protection committee, sorry. And but you also might have to notify the data subjects. If the violation is likely to cause substantial harm, then you also have to notify the data subject, might be notified. And I think the law stipulates a timeline of 72 hours, so it's a closed timeline. So my point here is you have to set up certain protocols to ensure that you can deal with these requirements once the law is in force. Next slide, please. Which brings me to my compliance slide. Yes, so the topic is new in Thailand, so companies are not that well prepared. So I think what you want to do in order to be compliant is, number one, you want to do a review. Which kind of data are you collecting here? What is coming from customer data, employees, and so forth? And where and how is the data stored? Saving it just on the laptop somewhere, putting it in a cupboard somewhere. Who has access to the data? Is there a system in place where only certain people get access to the data? All these questions need to be answered and summarized as a first step. Then number two would be to establish a protocol, right? Do you need to adopt the privacy policy? Do you maybe have another privacy policy in the EU, which you can then sort of bring over to Thailand and adjust it slightly? What about privacy notices and consent forms? You want to draft these documents and prepare them to use. What about data processing agreements? If you have a data processor, or if you are a data processor, should you have an agreement with the data controller to make sure that there are no mistakes in this relationship? What about your contracts? If you have the obligation to ensure privacy with subcontractors and so forth. So all of this has to be established. And lastly, obviously, you want to check if you need a data protection officer. I alluded to that before. Yeah, this would be necessary. And then lastly, once you have all these protocols in place, Obviously, you want to review how well is it working, maybe on an annual or biannual basis. Have I had any breaches, violations, and so forth? Are there any relevant updates? We are all praying to the committee to issue some guidance on how this is going to play out, but we are expecting that then there will be regular updates. In Thailand, by the way, might be issued in Thai in the beginning, so should probably be a Thai person to be in touch. And then, is your staff trained and aware? I think awareness is a little bit of an issue, at least from my experience. It's a little bit anecdotal, but I think there might be a lack of awareness of the issue amongst normal office employees and so forth. So I think it's very important to stress this point again and again. Hey, privacy is here to stay. It's important. Please take care. Which brings me to my next slide. Because if you are not compliant, then you're going to face liabilities. And the law has three different kinds of liability: administrative liability, which is just fines. So let's say you are not storing data in a secure enough way, you might get fined up to 5 million baht. So that's relevant. Then you have criminal liabilities. If you have a criminal breach of the PDPA, for instance, disclosure of personal data, which is likely to cause harm to the reputation, or even worse, disclosure of sensitive data, you can end up in jail for 1 year. So that's bad. And this is also very relevant for directors, because this liability can be transferred over to a director of an entity. If the entity is found have committed the violation, then the director can be held liable. Lastly, we have civil liability. Obviously, a data subject can sue for compensation. And on top of this, the courts can hand out punitive damages, not exceeding 2 times the amount of compensation. So a little bit of a slap on the wrist by the civil courts as well. So very important to be compliant. Which brings me to my last slide. Future of privacy in Thailand. So in the near future, what are we seeing? We're going to see the enforcement of the PDPA either this year or next year. I hope this year. I think we have a rising awareness of privacy issues, just as Clarice pointed out in the beginning. I doubted that we're going to see very strict enforcement of the PDPA in 2021, because I think they're going to need some time to come up to speed, to bring the regulator up to speed, to bring out necessary regulations, figure out all the issues, and then implement it. And there are some cases in Thailand where you actually have good laws on the books, but then administered maybe a little bit not so great in practice. So I think this is in the near future and midterm and distant future. I totally agree with Clarice. We see a growing importance of data privacy in light of Thailand's push to provide more digital services. Thailand wants to establish itself as a digital economy, and is very well prepared. We are all very online all the time. And so I think privacy is here to stay and will only gain importance over time. So it's probably a good choice to get compliant right away. And I think that European companies have actually an advantage here, because you have the experience with the GDPR. So you're, from my point of view, actually well prepared. And as Clarice said, you could contribute here in the discussion as well, because you got the experience. And this concludes my presentation here. And now we have maybe time for a quick Q&A. Yeah, thank you very much.
Yeah, thank you very much, Martin, and thank you very much to everybody who contributed to this very comprehensive overview of data protection and data privacy challenges and regulations in ASEAN at the time being. So we will be happy to take in your questions if you feel that there's something you would like to know just right now. Of course, as Clarice already indicated, we will be happy to share the slides with you of today's session upon request. And as this webinar is being recorded, we will make it available online later on for you and your colleagues to recap anytime you wish. So please feel free to submit your questions, and I will be happy to take them in and hand them over to the colleague in charge. So here we have one coming in, and this is referring to Thailand. So Martin, it would be your turn, please, to answer this question. If a company has to appoint a data protection officer located in Thailand, would it be possible to appoint a person in Germany so that we only have a single data protection officer?
Yeah, we got that question before. this is unfortunately not possible. The data protection officer has to be in Thailand. I understand that you would like to have a single point of focus in your company, but the data protection officer has to be a person in Thailand. So this is not possible. It's the same if you're a data controller in Germany, let's say, and you fall within the applicability scope of the PDPA, you actually are supposed to appoint a representative here in Thailand as well. So this is something to keep in mind. So you need to have a person here in Thailand who's doing this for you.
Thank you very much. So I have another question here, which is referring to Singapore this time. So I might refer to Paul for the answer. You mentioned that companies may collect personal data if there's a legitimate interest. I'm sorry. How do I know if my company has such a legitimate interest?
Well, the legitimate interest clause is very wide, right? There can be a lot of different aspects to be considered. So you need to carefully assess it, because actually the onus is in your company to later prove that you have a legitimate interest for the collection. So you want to make an assessment where you probably consider the purpose that you collect the data for and whether it's reasonable that you collect it for that purpose. And finally, I mean, it will be a balance between the benefits for you as a company to collect the data versus any potential adverse effects for the individual. So it is a whole exercise of assessment that you should also properly document to be able to prove that you have such legitimate interest. There are advisory guidelines which provide an assessment checklist, which could also help you to go through this process of identifying and proving your legitimate interest.
Thank you very much. So with regard to the time, I think we might come to a close, and I would like to thank all of you who participated in today's webinar, sharing their insight on data protection and data privacy, which is a really comprehensive and complex task to fulfill and to keep in mind and in view all the time. I think that's just one of the issues that needs constant monitoring more than many other issues in business life. So thank you very much for attending today's webinar. I hope you enjoyed it and took some helpful insights with you. Stay safe, take care, and should you wish to recap, we will share the slides and we will share the webinar link for the video for you to recap anytime you wish. So bye-bye, and thank you very much for attending.